rise. Chester of the Bishop Fourth Department. Hear ye, hear ye, hear ye. All present have the pleasure to give the support from here, give the attention and shall be heard.
Please be seated. First case for oral argument this morning is George Burlello versus Kathleen Hochul. Go ahead.
Good morning, Your Honors. Supreme Court erred at the outset by assuming that the plaintiffs had standing to challenge this regulation in the first place. Certainly none of the plaintiffs here have been threatened with an isolation or quarantine order, so any accusations about how this order would operate in conflict of statute or conflict with due process would be speculative. As to the Boreali challenge, the organizational plaintiff and the legislator plaintiffs both refer only to the generic harm to the general public that arises from such violations. The organization refers to its ability to advocate without any specific or personalized allegations as to why they can't advocate for their priorities due to this rule's mere existence. As for the legislators are referring only to the fact that a Boreali violation in the abstract is a usurpation of the legislative power. But the Court of Appeals in Silver and Silver's progeny both make clear that legislative standing requires more. Like any other plaintiff, legislators need personalized allegations of harm, and it is not enough to allege harm to the legislative body itself and to then rely on their status of as members. What we're seeing from the plaintiffs is basically an attempt to make Boreali into some sort of magic word. As they see it in this virtually limitless view of standing, if they raise a Boreali claim, virtually anyone, and certainly any legislator, could challenge any regulation with which they disagree. The Court of Appeals has not embraced a view of standing that's that broad. If anything, they've said that legislative standing is limited, and that's why this court should reject such a broad theory. If this court were to review the merits, Supreme Court erred on the merits as well. Virtually all of Supreme Court's reasoning boils down to a misconception that isolation and quarantine is synonymous with civil commitment. It's not. The defining feature of civil commitment is physical restraint. You are taken against your will to a place where you cannot leave. We acknowledge that PHL 2120, which is the law on which Supreme Court relied, provides for a civil commitment process, and it also provides for protections. But where Supreme Court errs is in finding that there's a conflict with that statute. If you look at the text of Rule 2.13, there's nothing in that text that invariably leads to the conclusion that the Department of Health can somehow take people away from the community and lock them up in situations where they can't leave. It's true that the Department of Health can order a person to isolate and quarantine, but the Department of Health can order many people and many entities to do all kinds of things. I'll note that 2.13G contains mechanisms for enforcement. It says anybody who violates one of these orders is going to be subject to any enforcement action available to the Department of Health under law. If this were civil commitment, we wouldn't have needed to put an enforcement mechanism in because you just wouldn't be able to leave. The door would be locked, or if you tried to run away, somebody would physically restrain you. And the fact that that rule says the enforcement mechanisms available under law is an additional signal that anything the department can do has to be consistent with the governing law. We acknowledge that if one of those mechanisms is to physically remove somebody to a hospital, the one and only way that the department or a locality can effectuate that is by following the procedure set forth in 2120. Now, I hope that one day nobody ever decides to try and commit somebody and claim 2.13 as the authority to do so. If that day ever comes, the affected person would have a very strong challenge that the order of isolation and quarantine itself is unauthorized. But that's not this challenge. This is a facial challenge that rests on the premise that PHL 2120 somehow is the sole legislative policy announced on isolation and quarantine, which was puzzling considering that 2120 doesn't use the phrases isolation and quarantine at all. It uses the phrase commitment. But there are other statutes like 2100, 2180, Chapter 25 of the laws of 2020. They do use the phrases isolation and quarantine, and they don't reference 2120. So if that was the only mechanism, those statutes would be rendered superfluous. In addition, this conception of 2120 undercuts plaintiff's own argument, or a key feature of it, which is that this rule is invalid, but the rules that it superseded somehow are valid. Those rules likewise allowed localities to issue orders of isolation and quarantine. Those rules did not cross-reference 2020. So if plaintiffs were correct, and if Supreme Court were correct, it means that the counties and the state have been going about this all wrong for the better part of 50 years and violating the legislative intent, which is also why this internal inconsistency with their argument undercuts their separation of powers claim. It's quizzical that over 50 years, if the department and the localities were violating legislative intent, that the legislature wouldn't have stepped in and amended the PHL to try and rein in that authority, but they haven't. And in addition, in defending the former rules, plaintiffs can't do that without acknowledging that the department has the authority to promulgate rules governing the subject matter of isolation and quarantine in the first place, which is what Boreali is all about. The fault line between the old rules and the rule at issue here is that 2.13 clarifies that the Department of Health, in addition to localities, can sign isolation and quarantine orders. That might be an allegation of statutory conflict. We allege, or we argue, that that is just not true. 2100 refers to all health officers without qualification. PHL 242 and 243 make clear health officers can be DOH employees, and in general, the public health law bestows upon the Department of Health the primary responsibility to control infectious diseases, and in fact lets the Department of Health oversee the localities. So if the legislature had wanted only localities to have this responsibility in this particular instance, we would expect unambiguous language, not something that's open to interpretation. Nonetheless, getting back to Boreali, it illustrates that what this rule does is exactly what interstitial rulemaking is supposed to be doing. This rule is clarifying health officers mean the state or localities. It's clarifying that when PHL 2100 refers to the control of persons infected or exposed, here's what that means. Isolation is if you're infected. Quarantine is if you're exposed. They both last only so long as to limit the spread of disease. That's exactly what's supposed to be happening.
But counsel, isn't there supposed to be some type of time limitation on how long that's supposed to be happening? I didn't see that. Where is the term of confinement? It doesn't determine where the term of confinement is. Are there definite time frames for the confinement in Rule 2.13?
So, Your Honor, just first off, I would take issue with the characterization of this as confinement. This is not confinement or civil commitment, but 2.13b requires that the order is going to include an expected duration. The definitions of isolation and quarantine in 2.2i and j say that they can last only so long as is necessary to prevent or limit the spread of disease. So in 2.13b, whoever's issuing that order is going to provide an estimate for what they expect that period to be. That, of course, is going to be subject to the monitoring of the person and making sure that their symptoms have abated. If the symptoms last longer.
Real quick, just looking at the regulation, its exact language, and following up to Justice Ogden's question, any isolation or quarantine order shall specify the duration of the order.
Yes.
It's not an estimate, correct?
Yes.
Okay.
So there's going to be a duration in there. I guess what I'm saying as far as reconciling it is that if the symptoms last longer, that would have to be effectuated by way of a new order that in turn would specify a duration, because every order has to include a duration under 2.13b. There's been an allegation that this rule is some sort of backdoor effort to enact A416, a failed assembly bill. It's well settled that the failure of one bill in one house hardly is going to be indicative of efforts of the legislature to reach a compromise on this issue, and then an agency is sort of swooped in and pulled the rug out from under them. Nevertheless, you can find the text of this rule on pages 116 through 119 of the record. If you read through that, you will see this bill is a commitment bill. So even if we had evidence that a critical mass of legislators opposed the proposition for committing people under the circumstances set forth in that bill, it sheds no light on what they would think about 2.13, which doesn't provide for commitment.
Just one last question for me anyways, is specifically which section or sections of the public health law does the state rely upon to authorize this particular regulation?
We rely on PHL 2100, which provides that health officers can control persons who are infected or exposed.
Anything else? I just want to get the list that you have, if you have one. If it's just 2100, I'll be sure.
It's 2100, and it is PHL 225-5J, which provides that the sanitary code shall
Give me
include
that again.
225-5J. And that's the regulation governing what's going to be in the sanitary code. I know that there was an argument raised that we were invoking 5A, which is a generalized power over all matters related to public health. That certainly supports this rule, but 5J is more specific. It says the sanitary code shall include measures regarding the contact and communication with infected premises that is reasonably read, certainly in conjunction with 2100, to relate to who can enter and leave those premises.
Counsel, so what does 5A permit?
5A permits the department to regulate all matters related to public health.
But you're not relying on 5A is what you just indicated because you find that 5J is more specific, correct?
Yes. Certainly 5A supports it, but we wouldn't put all our eggs into the 5A basket when we have more specific rules.
Do you have anything further?
Yes, Your Honor. With respect to the fourth Boreali factor and the claim that this violates due process, the text of the rules themselves resolve both of those issues because they show that isolation and quarantine is related solely to public health considerations. The very definitions of isolation and quarantine are anchored to public health. There's no question that the department is the arm of the state that has the expertise in public health. With respect to due process, once again, we're at this point where they're conflating commitment with isolation and quarantine and saying that the standards for commitment should apply. Federal courts have said that that simply isn't the case. We're very well aware that federal courts do not bind this court, but plaintiffs haven't shed any light on why those decisions wouldn't be persuasive. Instead, they argue that due process is more lenient for regulations than it is for statutes, and that the standard should be shock the conscience. But the Court of Appeals has said for substantive due process purposes, the standard is actually quite deferential. It's whether a law or a regulation is enacted for a public purpose and reasonably related to that purpose. Undoubtedly, this is a measure that's designed to operate in the event of an outbreak or pandemic of communicable diseases. Finally, I know that the claim was for substantive due process, but Supreme Court ventured into procedural due process. I want to point out to the court that any available enforcement mechanism, whether it's trying to get fines, whether it's the criminal process, whether it is a commitment proceeding under 2120, all of those enforcement mechanisms have due process protections of their own that are just not in dispute as far as their adequacy.
And judicial oversight?
So judicial oversight is in all of those enforcement mechanisms. And finally, in the regulation itself, for those people who want to oppose an order of isolation and quarantine, but don't want to disobey it, there's judicial review and a right to counsel there as well.
Thank you.
Thank you.
Good morning, Your Honors. If it pleases the court, my name is Bobby Ann Flower Cox. I'm here on behalf of the plaintiffs. I have my lead plaintiff with me here today, Senator George Borrello, I think we got a little bit off track here. I'm going to pull us back on track. The first thing I'd like to do is get on the record what this regulation actually says. And then I'll go into some of the details on how it conflicts with our existing.
We certainly don't need to read the regulation to us. We're
No, I'm not going to read it. I'm not going to read it. So, Rule 2.13 gave the Commissioner of Health the unbridled power to pick and choose which New Yorkers she could lock up. I'm saying she because at the time it was Dr. Mary Bassett. She could lock up or lock down. She didn't have to prove you were sick. She didn't have to prove you were exposed to a communicable disease. She didn't have to prove you were a health threat. She could issue an isolation or quarantine order at whim. It didn't have to be a state of emergency. That quarantine order or that isolation order would determine how long you were in lockup or lockdown. They could have locked you up in your home, or they could have removed you from your home with the force of police as clearly delineated in 2.13. With the force of police, they could have removed you from your home and put you into a detention center, a facility, whatever you'd like to call it, whatever noun you choose, it gets you to the same place. It's not your home and you don't get to pick where you go. They could have locked you up there for however long they wanted, no restrictions, days, weeks, months. There was no age restriction. So they could have done this to you, but they also could have done this to your child or your grandchild or your elderly parent. The provision said that they could tell you what you could and couldn't do while you were in lockup or lockdown. They could use the police in order to make sure you were abiding by their isolation or quarantine order. And if you disobeyed, you would be subject to either civil penalties, which could be up to $2,000 per day, and each day that you disobeyed their order was a new violation. So if you disobey their order for 10 days, that's $20,000 in fines.
Is there a cap?
I believe it was up to $2,000, yes, Your Honor. And so there was the civil aspect, and then there was also the fact that they could use criminal penalties against you if you disobeyed one of their isolation or quarantine orders. And when we were at the trial court last year doing oral arguments, the trial court judge specifically asked, if you issue me an isolation or a quarantine order and I disobey, I don't want to go, can you get the police to come and arrest me and take me to a facility somewhere? And the Attorney General's response was a resounding, yes, we can. That's what the regulation says we can do. So that's my overview of the regulation. It severely conflicts with the public health law. Okay, specifically, the lower court did not err when it struck down this regulation, saying that it violated, conflicts with Section 2120 of the Public Health Law, which since 1953 has been our isolation and quarantine law. In 1953, the New York State Legislature weighed they weighed the rights of the individual against the government interest in keeping our society safe, and they came up with this law, which is full of due process protections.
But counsel, did it really conflict with 2120, or did it exceed the powers delegated to the Department of Health by the legislature?
It's both, Your Honor. It's both. So the lower court ruled that and struck down this regulation because, yes, it conflicts with Section 2120 of the Public Health Law. It also conflicts with Section 2100 and Section 12 and 12-A and 12-B, but primarily the provisions of Section 2120, which is our quarantine law, are violated significantly by this regulation. And in promulgating this regulation, the lower court also found correctly that the Department of Health overstepped their bounds. We use Boreali in our analysis because that is what the Court of Appeals says to use. When you are trying to figure out, in New York State, when you're trying to figure out if an agency has overstepped their bounds and crossed into that legislative, lawmaking, policy-making realm, you use the four prongs of Boreali. And opposing counsel doesn't contest that. They use Boreali themselves. It's just that they argue that Boreali favors them. They think all 4 prongs of Boreali favor them. The trial court below has already said that the 3 of the 4 prongs of Boreali clearly favor our side, and that 4th prong, he did not rule against us on the 4th prong. He simply said it didn't weigh in favor of either side. However, in arguing Boreali, they say it works for them, we say it works for us. The whole premise of Boreali is it's only used as a test to determine whether or not an agency has overstepped their realm. And so, yes, to answer your question, the lower court said, we're striking this down because it conflicts with Section 2120, and an agency cannot make a regulation that conflicts with a law, which the Attorney General does not contest that. They actually say it in their own papers, both here on appeal and at the lower court level. They acknowledge that agencies have to have an enabling statute or statutes to give them the power to make a regulation. And in this case, they did not have one. Certainly they did not have one. If I could just point out a couple of the glaring conflicts between Rule 2.13 and Section 2120 of the Public Health Law. I do have a chart that I put in my brief, which starts on page 13. I will direct the court to that. It starts on page 13 and it runs, I think, till page 15 or 16, because there are a lot of differences between this regulation and the law. But I just want to go over a couple of the main differences to point out to the court today. First of all, our law, which we've had for 70 years, says that in order to even consider isolating or quarantining somebody from society, they have to first actually have the communicable disease that we're talking about here. Whereas Rule 2.13, there is no need for the Department of Health to prove that you are infected or exposed to a communicable disease. That is very clear in the language. The second thing that I want to point out on the conflicts is that once a doctor, according to the law, confirms that you actually are sick, and if they are concerned that you can't keep your germs to yourself, in essence, then the doctor would refer the matter to the local health authority. The local health authority, not the commissioner of state. The local health authority would then, if they think that there's a possible problem here with this person, they would start an investigation. And they gather their evidence, and if at the end of gathering their evidence, they think, yes, we have a problem here, this person is infected and is a public health threat, 2-prong test, then they refer it to a magistrate. And a magistrate, a third-party, unbiased judge, gets to look at the evidence. There is a hearing. The person is afforded an attorney if they cannot afford one. And there's due notice that a hearing is coming up. Whereas the regulation says they can knock on your door with no due notice and they can hand you an isolation or a quarantine order. Ex parte, no hearing, no due notice, no right to have an attorney before you get locked up or locked down in your house, no right to contest any sort of evidence against you. There is no evidence against you because there's no hearing provided in Rule 2.13. It says you have the right to an attorney and judicial review after you're locked up, right? It's guilty until proven innocent. It's tremendous.
We understand that.
Okay, sorry, getting a little emotional, sorry. So just one other thing on the conflict between the rule and the law, Section 2120 of the Public Health Law, is that the law clearly says that if the judge determines that, yes, you are infected and yes, you are a public health threat, you can't or you won't comport yourself in a manner to protect those around you, then they can issue an isolation or a quarantine order and put you into a hospital for care so you can get better. That is not what the rule says. The rule says the Commissioner of Health can pick any place that the Commissioner of Health wants to put you. You have no say, and including the words residential or, quote, residential or temporary housing. So it's a stark contrast to our law, which we've had for 70 years, which sets out the policy that our legislature carefully weighed the rights and the concern of the government, and then came up with this law. So that's what I wanted to say on the reg itself and on the differences between the reg and Section 2120 of the Public Health Law. We do also put forth.
Counsel?
Yes.
Forgive my interruption, but the other side indicated that they were relying on Section 2100 of the Public Health Law. There's two bases, 2100, and secondly, 225, 5J.
Yes.
And the 5A was probably too broad, albeit provides support. What about 5J? Doesn't that seem to provide for this kind of regulation?
No, Your Honor, it doesn't. So first, I'd like to point out that their enabling statute has been a moving target. We've been litigating this case for a year and a half now.
Well, we just heard two.
Yeah, we just heard two. Okay, so I'll go with those two, because all the other ones they've cited.
And for my
yes.
purposes, all I'm asking for is about 225, 5J.
Okay, so
It talks about established regulations in respect to contact or communication with or use of infected premises, places, or things.
yes, exactly.
Does
So,
it apply to people?
I'm sorry?
Does it apply to people?
It does not, Your Honor. No, no. And with statutory construction, as Your Honors know, we are compelled to first look at the actual verbiage that's used in a statute to interpret the legislative intent of the statute. So before we even start going through the archives and seeing, well, what were the debates like when on the Senate floor and the Assembly floor to see what did the legislature intend, we first look at the actual language.
And obviously, we're well aware of that.
Yes, no, I know. Yes, thank you. 225-5J says nothing about isolating or quarantining human beings. So it says they can establish regulations in respect to contact or communication with or use of infected premises, places, or things. That's it. So opposing counsel saying, well, that automatically kind of would assume that we can regulate people that go in and out of those places is absurd. I mean, it doesn't even pass the straight face argument here. When countless cases from the Court of Appeals have held that when the legislature wants to delegate their power to an agency, they have to speak clearly, especially in the area of constitutional rights. So if the legislature wanted to pass a law that enables the Department of Health to make a regulation that allows them to arbitrarily pick out New Yorkers with no proof they're sick, with no proof they've posed a threat to other people, with no hearing beforehand, no notice, no right to an attorney to represent them before they get locked up, then it's not in the public health law. If they wanted to make it a provision in the public health law, they could easily do that. And in fact, A416, which opposing counsel brings up, did try to do that. That bill was proposed since 2015. It came about because of an Ebola outbreak, and a New York City member of the Assembly proposed this A416. It had prior numbers beforehand, but most recently it was A416. And for 7 years, from 2015 straight through December of 2021, A416 was proposed in the New York State Assembly. It is the same sum and substance, which the lower court did agree, the same sum and substance as Rule 2.13 that the Department of Health has issued in this case. It got no support whatsoever. It was proposed in the New York State Assembly Health Committee for 7 years in a row. It never made it onto the agenda of the Health Committee.
I think we understand that.
Okay. It never went anywhere, is my bottom line. It didn't have a sister proposed law in the Senate. And the amicus brief that was submitted last year at trial court, which is part of the record before your honors, which was authored by Assemblyman Andy Goodell, gives a very detailed analysis of the treatment of A416. If you're interested, that is in the record before you. So I think it's clear that the Department of Appellants do not like our current New York State law our policy on how we remove people from society if they are a public health threat. They don't like Section 2120 of the public health law. They think it's not good enough in time of emergency. And they have made that very clear both at the trial court level and here on appeal. At the trial court level, when we had oral arguments last year, the Attorney General's office was crystal clear. In essence, this pandemic has shown us that we can't have, all these different courts around the state, deciding if someone should be isolated or quarantined. We need to centralize power. We need, here in Albany, Commissioner of Health, we need to centralize power and be able to control 19 million New Yorkers
I think we
with
have
the flick of a
finished.
pen, right? So if they want to change the law, if they want to change the public health law and make it more centralized, if they want to take out the due process protections that are currently in our quarantine law, all they need to do is ask the legislature to change the law. It's very simple. The Constitution provides 3 branches of government. Legislative branch is the one that's supposed to make law. So if the Department of Health wants to change policy and change the law, no problem, peddle your goods to the New York State Legislature and see if they'll change it. One last thing I want to just point out is our overarching question here on appeal is really, does the Department of Health have to follow New York State law when they want to remove someone from society who is a public health threat? And the overwhelming question, the answer to that overwhelmingly clear question is yes, of course the Department of Health has to follow law if they want to remove somebody from society because they feel that they're a public health threat. If they don't have to follow the law, then what's the point of having the New York State Legislature? And as far as standing is concerned, Silver v. Pataki, which is a Court of Appeals case, which is relied on heavily by opposing counsel, clearly says, when it's read and cited properly, clearly says that the judicial branch will always be available to resolve disputes between the other 2 branches of government when the other 2 branches of government are combating who has what power and who can do what. That is very clearly stated by the Court of Appeals in Silver v. Pataki. That court also said that if you are a legislator and you feel that you have been wronged by another branch of government because your power was either your vote was nullified or your power was usurped by another branch of government, you have standing. Silver v. Pataki makes it clear, and there are other Court of Appeals cases, but this is the one that opposing counsel relies upon, makes it clear, legislators have standing, and you only need one legislator. You don't have to have, Silver v. Pataki says that as well, you don't have to have the whole legislature on board. Even just one legislator has standing to sue if he or she thinks that their power has been usurped by another branch or their vote has been nullified. And since day one, we have been arguing that the power of the legislators has been usurped. That's the only reason you use Boreali.
I think we understand that.
So if you have any questions for me, I'm happy to answer them. If you do not, then I rest on my brief.
Thank you very much. Should we wait a moment? I assume most of these people don't want to stay in here. You're more than welcome to stay if you'd like to listen to all the evidence. Okay, we're going to continue with court. The next case for oral argument is People versus Casey Burke. No, and I'm trying to get Ms. Denman to do something.
Yes. Like he should be banging that gavel and telling people.
Can you make sure that people stop talking for in court?
Thank each and every one of you for letting us be heard.
Hold on a second, we can't hear
Thank
you.
you so much.
He thanked us for
Oh,
letting.
Thank you.
I couldn't hear you.
Thank you. You seem to say.
I didn't know what you had to say, and there's so much noise I couldn't hear. I thought he might have been Casey. Okay, didn't know who he was. You know,
Oh, okay.
like you called it, and then everybody left.
It was hard getting in here from the attorney conference room. They made a little mini stadium right there at the top.
Oh,
of the
you're kidding,
stairs.
I didn't know
Just
that.
like line the chairs up in a semicircle, so you were like completely blocked to get through. We'll be safe in the attorney conference room. We ended up trapped. Yeah.
Thank you for your patience.
Oh,
Really
no,
appreciate it.
I was just worried that we were immediately going to start rolling into the dockets.
I was trying to.
We heard you all tried to.
So again, 707, People versus Casey Burke.
Good morning, Your Honors, and may it please the court, I apologize for scaring nearly everybody out of the courtroom there.
Oh, I'm sorry, I thought you were gonna appear today.
No, I was scheduled for a
No,
virtual.
no problem, no problem.
All right. The Cortland County police officers in this case unlawfully arrested Mr. Burke on an arrest warrant issued by a local court in a non-adjoining county. Under CPL 120.70, a local court warrant may be executed within the county of issuance or an adjoining county.
And I think you understand that we know that, correct?
I do, Judge. I assume, I also suspect you know that Cortland and Jefferson are not adjoining and that this warrant was not endorsed by a local court judge when Mr. Burke was taken into custody. I think the plain language of CPL 120.70 contemplates the police first obtaining an endorsement before arresting somebody, and the statute.
And so your argument is that they did not follow procedure, correct?
That's correct, Judge. And because they didn't follow procedure, suppression is required. This court has consistently held that when police exceed their statutory authority to either detain or arrest, suppression is required. This case, I think, is even stronger than some of the cases I've cited in the brief, such as People v. McGrew, because not only do we have a statutory provision at issue here, but we also have a constitutional provision that limits the process of local courts. And so the rationale for
I think we understand all that. Do you have anything further?
No, Judge, I would ask Your Honor to Your Honors to reverse the conviction, suppress the evidence, and dismiss the indictment. Thank you.
Thank you. 708, People versus Anderson. Good morning.
Good morning. May it please the court, Melissa Swartz on behalf of Appellate Kelly Anderson. I understand that this court has had some lengthy arguments prior to mine, and you're utterly familiar with my arguments and everything that's raised, so I'd like to just get to the heart of the issues. If the court has any questions, or concerns on any of the issues that I raised in my brief, especially regarding the weight of the evidence and the eavesdropped calls, I'm happy to proceed in that direction now.
Any questions?
No question.
Thank you very much.
Thank you, Your Honor.
May it please the court, Todd Cassell on behalf of the people. I, like counsel, will respect the court's time. I know you have a busy docket. A couple points I wish to address, just generally speaking. As it concerns the legal sufficiency argument and the weight of the evidence, or legal sufficiency specifically, counsel in her reply brief concedes that in her main brief, she applied the wrong standard of review on appeal. Yet in her reply brief, she engages in the same type of analysis of the evidence. This is a circumstantial case. Guilt was only going to be established through inferential evidence, inferences that the parties would ask the jury to reach. What it really comes down to in a circumstantial case is which attorneys put forth the most reasonable and rational inferences for the jury to draw from the competent evidence at the trial. And I submit, based on the evidence that was before the jury, that they reached the right inferences which supported guilt beyond a reasonable doubt. There is a lot of evidence that predates the wiretap that I think really makes the meat and potatoes of this case. The recordings on the wiretap were really the icing on the cake. What this really starts
If that
with...
were true, counsel, wouldn't they have brought this indictment 19 years earlier?
19 years earlier, the district attorney at that time, from my understanding, did not believe the evidence was sufficient to support it, in so much as there were 2 adults in the house with Ethan Eslick capable of committing the murder. And pursuant to Wong, didn't feel there was enough evidence one way or the other. That's why we pursued the eavesdropping warrants, because I wanted to be absolutely certain that we had the right person charged with this crime. And what we got out of the wiretap was that additional evidence that really did put it over. The statements that Kelly Anderson made were so incompatible with innocence, they can't be overlooked. The fact that she would say, and I submit, and counsel disagrees with this, that when she, speaking to her brother Danny, and relaying to him the statement of her sister Tammy Kerr, Kelly Anderson says, and quoting her sister, Kelly did do this. She does not correct herself. I've listened to the call of Tammy Kerr. Tammy does not say that. Tammy says Kelly did not do this. But when Kelly relays it, she says, Kelly did do this. And that statement stood uncorrected, making it an adoptive admission. But when you look at all the...
So were all of these statements and things given to the defendant during discovery as required by 1730?
Absolutely, Your Honor. Absolutely they were. And what I think is important when we look at the calls, counsel takes a real issue with trial counsel's decision to stipulate to these calls. Everything came in through stipulation. Everything was provided in advance. She takes issue with the stipulation, and of course there's not an objection to the evidence she stipulated to it. But I submit that counsel on appeal is looking at the calls in the vacuum of the trial. She's only looking at the 39 clips that were played, where trial counsel had approximately 7,000 calls over a 90-day period. I ferreted that down to 39 clips. There were other incriminating clips. There were other clips where she's inconsistent with herself. I settled on those.
Could there have also been some clips that didn't incriminate her that were exculpatory?
Yes, and some of those clips were in fact played for the jury, where she says, acknowledging only 2 people could have killed Ethan. It's either me or Ron, and I didn't do it, she says. I played that for the jury. Any exculpatory clip that was connected to an inculpatory clip was played by the people pursuant to the rule of completeness. So exculpatory was played. But if you look at this from all the calls, and then you also look at the direct examination of Kelly Anderson, the first bit of that is her point by point going through every call that I used at the trial. Why? She had them in advance. Well, she had to, obviously, but she was able to prepare for that in advance because she had them in advance. She knew what was going to come. The universe of the trial was narrowed. Instead of 7,000 calls that could be used against her, it's 39 clips. That made the defense job a lot easier, I submit. So I don't think it was ineffective. There's a legitimate strategic purpose for doing that. Counsel pursued and advocated zealously for her client from the outset, from before She was even arraigned. She was moving for dismissal.
I think we have that.
Any other questions for me? Your Honors, thank you very much.
709, People versus Lewinsky, and Justice Nowak is recused on this matter. Just waiting for the other counsel. There we go. Okay, Mr. Punch.
Thank you, Your Honor. There is not and there should not be any case law that says that a single push can never constitute criminally negligent homicide.
Wait, hold on a second. Mr. Punch, did you say that there isn't a case that says that?
There is no case.
Okay, so maybe I agree with you if it was the word punch, okay? Or, you know, a single punch, sorry about that. But there are cases that talk about single acts. Single acts. Irby, for one, that actually was a single punch. And here we have a single shove.
Well, Your Honor, what Irby says that is under those circumstances, that single punch did not constitute criminally negligent homicide. It does not say that it could never constitute criminally negligent homicide. The decision has to be made on a case-by-case basis.
And Mr. Punch, isn't Irby an after-trial case?
Irby is an after-trial case. It's significantly different. There are, I think, three main differences between our case and Irby. One, Irby doesn't mention the force of the punch. Ours is on video. We know that it was an extremely hard push. Two, it doesn't say that the defendant was defenseless. In our case, the victim was defenseless. In our case, he had his hands down to his sides and they were talking to a third party. He had no opportunity to brace himself. And then third, we have an 80-year-old man. There's nothing in Irby that says that the victim was in any way particularly vulnerable. I think on that, our case is distinguishable from Irby, and it's more akin to Breidenbaker, which I cited.
Now, hold on a second. Breidenbaker, my understanding of that case is that was what I would call a sucker punch, okay? From behind with no warning at a very vulnerable spot in the person's head, and he wound up. I don't think this case is like Bryden.
Well, I'm not claiming that it's exactly like Breidenbaker. I'm saying that by analogy, what happened in Breidenbaker was a sucker punch. Here we have a sucker push. It knocked the victim off his feet onto the back of his head. That's what directly hit. He was looking at the defendant, but he had no idea. He wasn't looking down at his arms. He didn't see him. So, Mr. Punch, should he have had an idea, the victim, that he was, poking a lion, so to speak? That he went up there aggressively, called him names, threatened to kill the guy. Okay, I mean that's all in the grand jury testimony. Should he have been worried that he was poking the lion? Maybe, Your Honor, but it's not a defense to criminally negligent homicide. He was using inappropriate language. He probably shouldn't have been doing what he was doing.
He was aggressive. I don't think this is even contested. He was aggressive and he was the aggressor. Left his seat, walked over to the victim, told him he was going to kill him, told him he was a Marine, and pretty much threatened the guy, who then pushed him out of the way. I've seen the video a bunch of times, and and I think we'll all have a different view of what the video shows.
I understand what you're saying, Your Honor, but I think there's two things I would take exception to. He walked over to him aggressively. I say he wasn't charging. He did walk over to him saying, "Put your mask on," but there is absolutely no evidence that he threatened him at that time. The threat came 2 hours and 40 minutes earlier. The
Okay,
defendant's response to the threat was, come over, which they did. They argued face to face, and then they went and both sat down. The defendant.
Mr. Punch, the standard, here on dismissal of an indictment, as I understand it, is whether the grand jury could rationally have drawn the guilty inference, according to Grand.
Correct, Your Honor.
Rationally have drawn the guilty inference. So here the grand jury draws that inference. Could they take into consideration the video, which some could argue, perhaps, the defendant pushes the victim from underneath his chest and backwards, essentially lifting him off his feet and compelling him on the ground, leaving little doubt that the purpose was to put the person on the ground? Is that a legitimate, reasonable inference or rational inference for the grand jury?
Absolutely, Your Honor. It's right there in the video, and it's also in Dr. Eller's testimony. And that was going to be my second comment on Justice Bannister's point. He didn't push him out of the way. He pushed him off his feet and onto the back of his head. He could have shoved him aside with one arm, and then we wouldn't be here. But he decided to take a step, use both feet, use both hands, and launch him off his feet onto the back of his head.
We understand that. Do you have anything further?
Your Honor, I just, regarding the second point, the justification defense, it's along the same lines, but there's no reasonable view of the evidence that he was defending himself from physical evidence. The threat was really the only thing. The victim had his hands down at the side and they were talking. It doesn't justify physical force. The only potential thing is the threat that occurred 2 hours and 40 minutes ago, and both men had withdrawn from that. And for those grounds, the prosecutor was not required to charge justification.
Thank you.
Thank you.
Mr. Greenman, if you could unmute yourself, please. Thank you.
It takes me time to do technological things, Your Honor. I tell you. Thank you. I'm not expecting any applause from this argument, but it's a little bit different. Your Honor, may it please the court. Well, I just want to start off by saying two things in response to what counsel has stated. He talked about the age of Mr. Sapienza. Judge Tullio was well aware of the age differential, and she made a specific finding that the age had nothing to do with this, because the question is one of perception from Mr. Lewinsky. The second, Your Honor, is that the people continue to argue that Mr. Sapienza had somehow withdrawn from his statements. He never withdrew from his statements. This began at about 4:55, 5 o'clock in the afternoon, when Mr. Lewinsky was and it's interesting to note that Mr. Lewinsky was not the only one who, from time to time, did not have his mask on. There were other people in the bar who never had their masks on. And Mr. Sapienza never focused on them. His entire focus was on Mr. Lewinsky. He tells Mr. Lewinsky he's going to kill him. He's going to kick his rear end. He makes other threats to him. He's a former Marine. He's from Pittsburgh. He made it clear that he had something else in mind other than just telling him to take the mask off. Some time goes by. Mr. Lewinsky comes back into the bar ostensibly just to pay his bill. And he was in the bar paying his bill when it all begins again. And Mr. Sapienza starts it off and he's chirping away and chirping away. On one occasion, he had walked over toward Mr. Lewinsky. He was walked back. And this time nobody stopped him. And he walked all the way back up to Mr. Lewinsky, where he was standing with the owner of the bar. The owner of the bar is trying to diffuse things. Mr. Sapienza had nothing of that. He's standing there poking his finger toward Mr. Lewinsky's face. He puts his hand down at some point in time, but it's clear that something's going on. And the owner is saying to Mr. Lewinsky, Mr. Sapienza, he's about to pay his bill. Let's go. And he's telling our client's paying his bill. Mr. Sapienza unfortunately did not walk away as he should have. And the statements continued to a point where our client was basically blocked at that point in time at the bar. His back was to the bar. Mr. Sapienza continued to stand directly in front of him when our client pushed him away.
Mr. Greenman, real quick, on that point, I've looked at the video many times as well. Your client, after the push, says a bad word and refers to the person as laying on the ground, and then does not walk out the bar. He turns around to pay his bill. So it's not as though the victim was obstructing his exit or his movement. Your client was there, according to the video, to pay his bill. In fact, after the victim was on the ground, he continued to stand there, pay his bill, and only thereafter exit. Do I have the facts correct?
Well, in a way, Your Honor, partially, respectfully, Judge. Our client was attempting, he had walked back in the bar, his son had played in the band, he had walked back in, he was finished for the night, and he was going to pay his bill. The chirping began again from Mr. Sapienza. It distracted him for a few seconds. He went back, and then immediately after that, Mr. Sapienza walked directly over to him. And it wasn't like he was going to be able to turn his back, pay his bill when Mr. Sapienza, nobody knew what he was going to do. And even the owner of the bar was trying to diffuse it. He's saying to Mr. Sapienza, he's paying his bill, you know, but he didn't stop. He stayed where he was, Your Honor, for the whole time. Our client, then he pushed him, then he went back and paid his bill.
Mr. Graham, I'm sorry to interrupt you again, sir.
Sure.
You make a lot of good points, and let's, you know, maybe there's a version of this case where there's no way, no how the jury would convict after trial. And you've just made a lot of good points that you would make in your closing argument. What I'm struggling with is the standard under Grand. We have to find that the grand jury could not have rationally drawn a guilty inference based on looking at this video. And that's the only way we can get to an affirmance here, correct? That we have to be able to say a grand jury, reasonable person, whatever you want to call it, could not rationally have drawn a guilty inference here. It's the pre-indictment, or it's the post-indictment pre-trial context that we're in that's really troubling me the most. And
I understand that, Your Honor. But a motion to dismiss an indictment is not intended to be without teeth. Our brief talks about the grand jury system and what the system is supposed to be all about, because it's not a simple thing to say, well, maybe a jury might have found differently. That's obviously, Your Honor, surmise. But the question is whether under these facts and the law, whether Mr. Lewinsky should be held to go to trial and to go through the ordeal of going to trial.
I think we understand all that. We understand all that. Do you have anything further?
I have one more question for Mr. Greenman. All right, we talked a lot about the facts. Let's talk about the law for a second, okay? Judge DiTullio found this case to be similar to Irby, but Mr. Punch did not. What do you have to say about the applicable case law?
Your Honor, the case law is, I believe, specifically in favor of Mr. Lewinsky. Irby, Your Honor, is on point. As a matter of fact, one may say that in Irby, the facts might have been worse than they appear in this case. The people's really, they only find one case, which Your Honor has already indicated you find to be an opposite to our case. It's interesting to note that in Breidenbecker, that was a case where the case went to jury and went to trial. And that was the case, the trial judge was Judge DiTullio, who's the same judge who found that the proof here was not even sufficient to get past the grand jury process. And it was Judge DiTullio who found that under the case law, and she cited all the required cases, to find that the proof is insufficient to go further in this prosecution. So the bottom line is, Your Honor, the people concede that they have no cases to support their position. They just want to say that a person in our client's, Mr. Lewinsky's situation, who was threatened to be killed, threatened to have his rear end beaten, where this man has come over twice to see him.
You don't have to go through all the facts again. We understand.
And I won't, Your Honor. I think that if we take this case, the facts into the context of what the law is and what the requirements of the law, in order to be charged with and or convicted of criminally negligent homicide, It has to be a gross deviation, and it goes on from there. All the language which defines a criminally negligent homicide, I think, winds up on the side of Mr. Lewinsky when we talk about where the case should be and what should happen here. This is an unfortunate situation. We all understand that. But the bottom line is that a push under these circumstances should not be sufficient to sustain the grand jury's vote in this particular case. And under the circumstances, you know what we're asking for, and I appreciate that.
Thank you very much.
Thank you very much, Your Honor.
710 People versus Weeks. Just need Mr. Noah. I mean, Judge Noack to come back, and we need Mr. Keene. There we go. Morning, can you unmute yourself, please? Thanks.
I'm working on it. Thank you. Good morning. May it please the court. Brad Keem for Mr. Weeks. We contend here that defense counsel's errors deprived him of a fair trial, and I'd like to particularly focus in on voir dire. Juror 5 revealed that he personally liked the prosecutor, that his son and the prosecutor's son played hockey together, but that wasn't the worst part. The worst part was when asked if he could unequivocally state that his relationship with the prosecutor would not prevent him from being fair and impartial, he could only muster, "I was wondering that myself. Probably. That's a good question. I don't know. You'd like to think so. I don't know how to answer that." I understand that the standard for ineffective assistance is high, but without explicit assurance as to his ability to be fair and impartial, defense counsel's failure to exercise a for cause or peremptory challenge, and he had 15 extra in a predatory sexual assault case, which is something I've never seen, was inexplicable. It lacked strategic explanation, and it denied appellant meaningful representation. In terms of the other issues with defense counsel's performance, we'd rely on our brief. But if the court doesn't have questions on that issue, I'd like to focus in on some of the things that happened at sentencing. Specifically, Rachel, appellant's ex, was permitted to make several outlandish and unsupported claims at sentencing. And considering that this is a 23 to life case, those sentencing minutes are going to be very important at potential future parole hearings. And we'd ask that new sentencing proceedings be ordered in which defense counsel would have an opportunity to more clearly and thoughtfully respond to those kind of claims and allegations. Speaking of the sentence, 23 to life here, he could have received 10 to life. There is an indication in the record that he was offered a 10-year term to satisfy the charges. The people did not dispute that when defense counsel made that claim. He would assert that that kind of disparity should compel this court to exercise its discretion and modify and reduce the sentence. I've raised several other issues on this brief, but if this court has no questions on those, then we will rely on it.
Thank you.
Good morning, may it please the court. Chris Eagleston in response for the people. I reread my brief this morning and realized I was very close to the word limit, so anything I might have to say here must be contained in that brief. But I'd be happy to answer any questions that the court may have for me.
Thank you.
Thank you all very much.
713, Hayes versus Holtz. Morning. Morning. Just waiting for Ms. Richards. There we go. Thank you. Go ahead. Oh, you need to unmute yourself. Ms. Richards, can you? There you go. Perfect.
I'm sorry. Can you? Oh, I'm sorry.
Go ahead.
I'm sorry. Thank you for your time. I represent the appellant in this matter, Daniel Hayes. Her argument is that the court erred and abused its discretion in modifying the 2017 order to essentially expand the father's parenting time. I believe that the first part of the inquiry that must be addressed is whether there are sufficient change in circumstances. I don't think that issue has been contested. I don't think that issue is in contention. Both parties filed filed a petition to modify number one. So number two, I believe there was testimony. The record would show that there was testimony that there was an acrimonious relationship between the parties, and number three, it showed that it had a negative impact upon the child. So I don't think there's that issue of whether there's a sufficient change of circumstance that warrants a real need to modify the order. I think what the mother is looking at is what should that order look like. We're looking at the best interest inquiry. Under the best interest inquiry, first of all, the court didn't hold a Lincoln hearing. Number one. Number two, I believe that the mother had several concerns, but has several concerns that she vocalized about how to address the negative impact on the child how to address the impact on the child. I believe she mentioned at one point not letting the child travel on the bus, things like that. But in the whole, I think that if you look at the record, we would think that it should be remanded for further inquiry under the best interest factors.
Thank you.
May it please the court, Mary Hope Benedict for the child Alice. Just first of all, the court is clear that if both parties file a modification petition, the issue of changing circumstances is conceded. I think Judge McCarthy was very clear in his decision that it was based on essentially reducing the contact between the parents. These parents are extraordinarily hostile, even in the presence of the child. The child has, aside from that, they're both perfectly appropriate parents, and the child is closely bonded with each of them. I would ask that the court find that family court's decision has a sound and substantial basis in the record and that it not be disturbed. Also, for the court's information, both parties have since filed additional petitions with family court that are pending. So the father has filed a modification petition. The mother has filed at least one, maybe more violation petitions.
How old is the child now?
She's 7, Judge, 2nd grade. She's a little spitfire, cute as can be, but she is very, very concerned about there was no Lincoln hearing because of her fear of upsetting each of her parents. And so that's why there was no Lincoln hearing. The AFC has never had permission to repeat anything that the child said. That's pretty extraordinary. So thank you for your time.
Thank you.
714, in the matter of Michael Jaremski Jr. versus Stacy Berardi.
Good morning, may it please the court. I'm Kristen McDermott on behalf of Stacy Berardi. The order of protection in this case is based solely on the finding that Ms. Berardi committed harassment in the 2nd degree by posting on social media, and there was insufficient evidence for that finding. Mr. Jaremski only put one Facebook post into evidence, and that's the Shirley Temple post that's in the record. That post on its face doesn't seem to have anything to do with him. There doesn't seem to be a connection to him. His only testimony about it was that that was Stacy trying to antagonize me, but he didn't provide any context or explanation of why he thought that post had anything to do with him. The only testimony that Mr. Jaremski gave about her Facebook post before the petition was filed is on page 242, where he simply says that at the end of their relationship, she made negative posts about him. That, without any evidence of the content of those posts, that's not sufficient evidence for harassment. And I would rely on Daniels v. Davis, which is a similar case, where this court said, without evidence of content of telephone calls and text messages, there's no proof of the intent to harass, annoy, or alarm, or that there was no legitimate purpose. Of course, there is a wide range of posts that someone can make on social media that another person would perceive as negative posts that wouldn't...
Yeah, we understand that.
Okay. In terms of the post petition shouldn't be considered, but even if it is, there still wasn't enough context, and there also was no proof of identity. He wasn't identified in these posts.
Anything further?
I would just like to address the fact that it's my understanding of the case law, when an order is based solely on one offense and there's insufficient evidence, the appellate court will dismiss the petition without considering whether a different offense was proven. As this court is aware, below, Mr. Grimsky relied solely on the clothes on the lawn, but the referee explicitly rejected that. So it should not be the basis.
Thank you.
Thank you.
7:15 in the matter of Anya J. Did I say that correctly?
I think so, Judge.
Okay.
Close enough.
Close enough.
Good morning, Your Honor. May it please the court. Phil Rothschild.
Wait a minute. Wait, just wait for Ms. Sullivan to appear.
Phil Rothschild, Hiscock Legal Aid on behalf of Katara J. First point.
We're waiting for...
Oh, still. I had to wait to get in the courthouse this morning.
I know. Go ahead.
First point I would like to address is the denial of adjournment. We submit that it's error simply because, in this case, the court reluctantly, and 6 months into the litigation, assigned a guardian ad litem. This is after defense counsel provided psych reports showing that Katara had mental limitations and was very vulnerable. In this case, there was a guardian ad litem assigned, but he did nothing. Absolutely nothing. Did not even bother to talk to his client, and just the only time he appeared in court was to be relieved. Now, I noticed that neither opposing counsel in their briefs really addressed this. So we have a guardian who's charged with a task and doesn't do the task. And I would submit that what occurred in the hearing actually underlined and emphasized why it was so important that the guardian do their job. Katara showed up late for the final hearing, I believe 2 hours late, with her new boyfriend in tow. That boyfriend basically told the attorney, don't talk to her.
And then they left.
But additionally, the DSS caseworker, I believe her name was Zuckerman, put on the record, we believe this person is very manipulative. It's very abusive, and we think that he has put her in the hospital. Now, during all this, the guardian ad litem is basically acting like a potted plant. And defense counsel, in his motion, in his request for an adjournment, says, Judge, we have here a very vulnerable client, and we have proof that this person's coming in here, manipulating her, abusing her. And the court says no and does nothing, and in fact dismisses the guardian because Katara never technically appeared. Now, the court must ensure that litigants' constitutional rights are protected, and that's even more true when you're talking about a vulnerable client. Here, despite clear signs that Katara was being manipulated, abused, during the actual litigation, the court does nothing. At a minimum, the guardian ad litem should have joined in the request for an adjournment in order to do his job, talk to Katara. This was the whole.
I think we've got that.
Yeah, Hayden, and I would submit the Justin case is even more illustrative, because in this court found reversal because there was a denial of a hearing to determine whether the guardian should continue. Here, what's the point of assigning a guardian ad litem if the guardian doesn't do their job, if they don't do anything? And also, we would submit that moving the docket along is secondary to the desire to protect vulnerable litigants, and the court's discretion is limited in those cases. Additionally, we would submit that there was no showing or even a claim that a delay in this case would harm the child. We submit the judgment should be reversed and the matter should be remitted for new proceedings before a different judge. Now, the second point I'd like to address, and the removal of initial counsel. The court, before all these proceedings even began, said, I'm removing her because she assisted the aunt in filing a custody petition. Not that she was representing her, not that she had signed on to the thing, but she had assisted her. This is an open secret. In TPR cases, oftentimes your last best hope is to try to get a relative to do this. Now, to declare this to be a per se unwaivable conflict without even asking, and by the way, Qatar was the one who wanted this, to make that determination is not only contrary to the law, it's also contrary to public policy, because Onondaga County, it's not that the attorneys don't have time to do this. Onondaga County doesn't provide resources or attorneys to help people in filling out these petitions. So any type of impact is going to be disparate and overly harmful for those people who cannot afford to consult with an attorney to help fill out a petition. So making it a per se conflict was wrong. And also, there's no showing of an actual conflict here. I understand the court must do more than just say, well, they were talking about possible, potential, speculative conflicts. There was no examination. We would submit that assisting someone else, there was no showing of actual conflict here. The harm in this case was immeasurable because Katara went through 3 different attorneys. She wasn't cooperating with any of them. This changed the whole outlook of the case, and we would submit for this reason as well, this matter should be reversed and remitted before a new judge. Thank you.
Thank you.
Good morning. May it please the court, Erin Welch-Fair on behalf of Onondaga County Attorney Robert Durr for the Onondaga County Department of Children and Family Services. First, the Onondaga County Department of Children and Family Services would like to reiterate that the court was right in this instance in denying the Mother's Counsel's request for an adjournment, and that the matter had already been adjourned at the mother's request approximately 8 months prior, and so the permanency for this child was already substantially delayed. This is also distinguishable from the Hayden matter in that this isn't a case where the mother simply non-appeared at the trial. The mother was contacted by the court or herself contacted the court to state that she was running late. The court delayed starting the trial approximately 2 hours. The mother, in fact, came to the courthouse, stated affirmatively she was not participating in the trial, and left. The court then, during a lunch recess, afforded the mother's attorney an opportunity to speak to the mother, which he did, and she stated that she would be coming down to sign a surrender agreement, which she failed to do. There's simply no showing that a further adjournment would have resolved the case in any other fashion. This child is deserving of permanency. While the Mother's Counsel states that the guardian ad litem failed to do his duty, the record doesn't bear that out. The psychological evaluation that was relied upon by the mother's trial attorney in his appearance in March prior to trial, in which he requested the guardian ad litem, made a sort of a curious recommendation to the court that the mother was capable of consenting to a surrender, but she was incapable of assisting in her own defense. So the court, erring on the side of caution, did assign a guardian ad litem. However, that guardian ad litem, in keeping with his attorney's decision to stand mute at trial to preserve the mother's right to reopen the default, didn't intimate anything further at the trial. And the guardian ad litem's role, as the court sees it, and I believe as the case law bears it out, is not to act as a chorus with the mother's assigned attorney, but to stand in her shoes as the client, so the mother's current assertion that the guardian ad litem should have voiced the same objections that were already competently made by her trial attorney is simply without merit.
We'll look at that. Thank you.
If I may just take a moment to step back too, because the mother's brief relies heavily on the information that was obtained through the trial, both at fact-finding and at disposition, in that the circumstances that make the mother a sympathetic litigant are also those very same circumstances that existed at fact-finding, they existed at disposition, and they still currently exist that make her unfit to parent this child. The child was removed from the mother's care at 10 months old. She's now 5 years old. She's been in care for over 4 years, and the department would assert that she's deserving of adoption by the only family that she knows. And for that reason, the department respectfully requests that
Counselor,
this court
let me just take you back
uphold.
real quick. Just
Sure.
a small question, which is, at the time that Attorney Bozeman moved to reinstate becoming counsel, was Mr. Gilhooly still counsel?
So I believe that Mr. Gilhooly appeared with the mother. The mother asked to terminate Mr. Gilhooly's representation of her.
And was there an order signed discharging Mr. Gilhooly at that time?
I'm not sure, Your Honor.
So technically speaking, do I have it right that Mr. Gilhooly, at the time the motion was made, was still counsel for the mother? If not, that's fine. I'm just curious.
I'm not sure, Judge.
Okay.
I do know, though, that Mr. Gilhooly was terminated because the mother stated to the court that she was wanting to hire counsel, that she stated affirmatively she was not looking to hire Ms. Bozeman, that the court then proceeded. Ms. Bozeman was not counsel on record at the time that she filed the motion to be reinstated, obviously.
You've answered my question. I'm all
Okay.
set. I didn't mean to- Thank you
All
very
right.
much.
Thanks so much.
Sullivan? Can you unmute yourself, please? Wait, you need to unmute, yeah, thank you.
Sorry, I believe I joined, you're welcome. I believe I joined the wrong way. Is that okay? I can't see you guys at the court, but.
Oh, you can't see us? We can see you.
Okay, as long as you're okay with it, I'm okay with it. I'm Catherine Sullivan, attorney for the child Anaya. I won't restate what Ms. Welch-Ferris said with respect to arguments, as it is essentially what I was going to argue in answer to Judge Curran's question. I believe it was his question that whether Mr. Gilhooly was still attorney for appellant at the time that that motion was made by Ms. Bozeman. It is my recollection from the record that he was in fact her attorney, and that was an argument that I made in my brief, that the proper person to make a motion at that time on behalf of appellant was her attorney of record at that time, Mr. Gilhooly. And he was perfectly in a position to make that motion if that was his client's wishes. So it was inappropriate for Ms. Bozeman to make that application in her motion when it was Mr. Gilhooly's job to do so. And I hope that answers your question. And I hope the record bears that out, but that's my recollection. With respect to an update, I'm sorry,
I thought you were finished. Go ahead.
With respect to an update regarding Anaya, she's doing well. She is now 5 years old. She started kindergarten. She has been diagnosed with significant autism. She is verbal, and so it's not very severe, but it's quite significant. She attended a special preschool for children with disabilities last year. She has started kindergarten and is doing well. She's bonded with her foster parents, the only family that she knows, and they are bonded with her and will too. My client deserves permanency. She deserved it when the TPR hearing was heard, and she deserves it now. And to delay it any further is unjust and not consistent with the law. Thank you.
Thank you. 716 Joseph Callaway versus American Park Place.
Morning, Your Honors. May it please the court. Ann Campbell on behalf of defendants. The only issue, the sole issue before the court today is whether Supreme Court properly granted the plaintiff summary judgment as a matter of law on the question of Labor Law 240. We're here to urge the court to hold that that was an error. The plaintiff clearly always has the burden of proving in the first instance that there was a statutory violation by the defendants. We submit that there is no such proof in this record.
Okay, let's go through that a little bit.
Okay.
So, there was two ladders. Okay, sorry, counsel. Okay. There were two ladders. Plaintiff was on one ladder. And because of whatever happened with moving the load, you know, the ductwork, the ladder and plaintiff fell to the ground. Okay, both the plaintiff and the ladder fell to the ground. And how does that not violate 240? We have a safety device that did not live up to its, to what it was supposed to be, to keep plaintiff from harm.
Well, with all due respect, Your Honor, what you're suggesting and what the Supreme Court held is that the mere fact that the plaintiff fell proved the violation.
Nope, I'm more suggesting the fact that the ladder fell.
Well,
okay. And in doing so, the method that they were using to remove the ductwork deprived plaintiff of being safe. They required him to lose 2 points of contact with that ladder by being on, you know, high and reaching up with two hands to take that ductwork down. So
that point was never raised, Your Honor. So I would suggest that that point was never raised about the 3 points. Okay. My understanding is that when you're coming down the ladder or going up the ladder, but that wasn't raised in this case.
Well, they did discuss the fact that he had to reach up with both hands and remove the bracket, remove the ductwork from the bracket, okay? So at that point, we have a loosey-goosey load, don't we? Okay, we don't have one solid piece of wood or something. We have a ductwork that has joints and things of that nature, and the two of them are supposed to act in sync on a 10-foot ladder, and sort of like a ballet, I'm imagining, you know, one step down, somewhere that didn't quite go perfectly. The ductwork was no longer controlled by the plaintiff, who, you know, it hit the ladder and they both came down.
Well, I have a lot to say, and I'm trying to figure out the order in which I want to say it. But so the plaintiff, in support of his motion for summary judgment, submits the deposition of Brian Gomeski, who is the foreman.
That's
and
right.
The foreman has 15 years of experience. He's worked on ladders before. He's worked many times at heights. And he testified, and he's had OSHA training. He's testified that this is standard practice. We do it every day. We're not talking about a huge length of ductwork. We're talking about an 8-foot length. And it's no bigger than this piece of paper as far as the dimensions, right? So he says this is a perfectly acceptable way of doing the job. It's done all the time. The plaintiff himself said he had done similar jobs in a similar manner. So our position is right from the get-go, the plaintiff never counters that, right? Never counters that testimony. We submit that that testimony alone does not establish his prima facie case of proving there's a statutory violation. I think what Your Honor is suggesting is that the fact that the ladder itself, or the plaintiff fell from the ladder.
The fact that the ladder fell.
Okay, but there's also testimony from Mr. Gomeski that the ladder didn't fall first, or it didn't fall contemporaneously with the plaintiff. The ladder fell a few seconds later. So.
And isn't it questionable? Didn't the coworker fill out a report about the happening of the event and then testify slightly different as to when?
Well, there's a slight discrepancy, Your Honor, slight discrepancy.
Because he said the plaintiff lost his balance and that was why he fell.
Well, Mr. Gomeski said there was nothing wrong with the ladder. I mean, there's no question. I don't think there's any proof that there was anything wrong with the ladder in this case.
And the plaintiff doesn't have to prove that in any event, that there was a defect in the ladder. There's plenty of cases that say that. That's not the issue, right?
Well, the plaintiff himself testified that the ladder was securely stable. Those are his own words. It was securely stable. Mr. Gomeski said the reason that this accident happened was because the plaintiff said, "I'm ready, let's go ahead and cut," and he wasn't ready. It slipped from his hands.
Don't we have lots of cases, Ms. Campbell, that say something to the effect of when there's a statutory violation, when the ladder is not properly placed to provide proper protection? I'm looking at I think a concurrence I did in a case called Wolf versus Ledcourt that set forth all of those cases about proper placement of the ladder. You agree that we have cases that say that?
I do, Your Honor, and trying to prepare an oral argument with the multitude of labor law cases, I would suggest, I don't know that case per se, Your Honor, but how was it improperly placed? There's
It
no.
fell. It wasn't properly secured.
To give
It
him
fell.
proper protection as the rest of the statute, and in this case, it fell.
What about the fact that the ladder didn't fall? He fell from the ladder fell a few seconds later.
Let's talk about the co-worker for a second. I'm going to give you a little break, but the co-worker, maybe this isn't such a break. He did testify that he didn't really see it, that he surmised certain things by what was happening, but he was paying attention to what he was doing. And so he really couldn't tell us exactly what came first, the load hitting the wall and then hitting the ladder, et cetera.
Right.
Or how the plaintiff might have, even if the plaintiff did mishandle the load, that ladder's supposed to keep him from falling. You know, I guess my point was, the co-worker really didn't have, it wasn't an eyewitness to what made the ladder fall. He clearly said he was paying attention to what he was doing.
Well, I guess I would take issue with that, Your Honor, because the plaintiff testified that it was a little unclear from the plaintiff's point of view, too. His testimony is not all that clear. And at one point, he said that the strap kind of broke unexpectedly. But Mr. Gomeski was pretty clear that he never saw the
We'll
ladder.
look at that
I'm
very
sorry.
carefully. 'Cause
The strap.
you're right, there's a discrepancy in that testimony. So we
Right.
understand that. We'll look at that.
Yeah, he never said that.
Anything further?
Well, yes, Your Honor. The defendants cross-moved for summary judgment, and in so cross-moving, they submitted an affidavit from a safety engineer, Ernest Gaylor, who testified similarly to Mr. Gomeski that the ladders were an appropriate device and that they are used all over New York State in a similar manner, and the plaintiff never countered that evidence in any way.
But like habit evidence, or, I mean, if somebody does something unsafe all the time, just because it happens all the time doesn't make it safe.
But, Your Honor, as Mr. Gaylor emphasized, the ladders were in good condition. They were securely stable. This was not a heavy or big load. It's something that's done all the time.
So do you think we can accept what Mr. Gaylor says and still find that the ladders in this situation did not give proper protection to this plaintiff?
No, Your Honor.
Okay, we'll look at that. Thank you.
Thank you.
Good morning to the court. Jason Paselovich here for the plaintiff and respondent. I guess I'll start, if it's okay with the court, with the proximate cause issue. There's no dispute in the record that my client was operating under the direction and following the example of his foreman and going up the ladder with him to cut down this ductwork and so on and so forth. The opinion of Mr. Gaylor, the expert engineer, and then some of the testimony from Mr. Gomeski as to whether or not my client was holding the ductwork properly or hand placement, I'm loath to concede this, but I would say comparative fault at best, which is not a defense for proximate cause. There's no question that, no allegation, I should say, by the defendant appellant that my client was doing something recalcitrant or in any form or fashion while he was on this ladder. So Mr. Gaylor's report and Mr. Gomeski's testimony as to whether or not my client had an adequate grip on the ductwork, I think is, if not irrelevant, probably irrelevant, but it goes to comparative fault at best. As to the ladder falling, the record is also undisputed that the ductwork slipped from my client's hands, broke free from the strap, hit the wall, and made contact with the ladder, causing the ladder to collapse, tip, or otherwise fail to form its function, to use the verbiage in the case law. So, I know I'm biased, I represent the plaintiff, but to me, a strict liability, standard Section 240 labor law case.
Anything further?
No, ma'am.
All right, calling the next case, 717 Cary Spring versus Allegheny Limestone Central School District.
Good morning, Your Honors. May it please the court. I'm here today on behalf of the defendants, the school district, and the principal, appealing from the order denying our motion for summary judgment. There's only a single claim in this case, and that's for the alleged wrongful death of Gregory Spring resulting from his suicide during summer vacation after his sophomore year of high school. There have been a number of these cases, unfortunately, working their ways through the court systems. Over the last few years, a lot of them end up in federal court. The allegations are 1983 claims and such, and there is a companion federal action in this case, but for the longest time, there's been no appellate division level precedent on this issue. And there is now. Last year, the second department issued a decision in Boyle versus Brewster Central School District, which we contend is directly on point, if not a case with less persuasive facts than we have here, that our case is even more subject to dismissal than the case was in Boyle.
Is this more about the existence of a duty or the scope of a duty, would you say?
Your Honor, it's fundamentally the existence of a duty, because the existence of the school's duty ends when the student passes out of the school's, quote, orbit of authority. And at that point, the parent is...
Irrespective of what occurs on school grounds prior to that departure. That's your position.
Yes, Your Honor, unless the school relinquishes physical custody after it creates a foreseeably hazardous situation.
Once you use the word foreseeably, at least in my book, now you're talking about the scope of the duty. So you're beyond the existence of a duty, and now you're in the scope of the duty. Do you agree with that, once you get into foreseeability?
I don't, Your Honor, because the question is, what was the conduct of the school district, if any? And I think we can look back to this court's decision in Dang. There, that was where the teacher sent the child home to walk when he had missed the bus and the child was hit by a vehicle. There, this court looked at the school district employee's conduct to determine whether a duty existed underlying as a matter of law. And here, that's the fundamental factor that's missing.
Why is that missing? I mean, in this case, the school employees were told repeatedly about this bullying and how it was affecting this child, et cetera, and did nothing.
Well, that's certainly what the plaintiff is alleging, but here we have an...
Well, even the school official admitted that, yes, he did receive this kind of information.
The key, Your Honor, here is that the suicide occurred off premises, off school premises, not even...
And that's a factor, but it doesn't alleviate the duty, or obviate the duty, I suppose.
It does, Your Honor. We believe as a matter of law, it obviates the duty. In order for, after that fact, there to be any duty, there has to be facts suggesting that they relinquished control of Gregory to his parents in a situation where they were foreseeably releasing him into a hazardous setting. And there's not one fact in this entire record to suggest that anyone, including Gregory's family, had any notice that a hazardous situation existed that could lead to his suicide.
We'll have to look at that carefully.
Well, and Your Honor, I would respectfully request this court in particular look at the Boyle case. It's directly on point. There, the allegations were almost identical. The student committed suicide off the school property.
But weren't the allegations in Boyle more focused on missing signs
with respect to the child when the child left. That was the concern. That was the mistake that was alleged more in Boyle, whereas here, the mistake is a little bit different. The mistake comes back to not addressing the allegations of bullying, and in fact, even perhaps go one step further than the presiding justice did, punishing the child when the child was bullied and brought it to the attention of the school. Isn't that in this record as well?
Well, I would say, Justice Snow, I think in a sort of an oblique way, you've hit on an excellent point, because in that case, in Boyle, the issue was that the child had actually threatened to harm himself and others. And even with the existence of those facts, there was still no duty. There was still no notice as a matter of law. And here we don't have any facts that even come close to that. And I would also point out that, the basis of the plaintiff's claim is a negligent supervision one. And the duty to provide adequate supervision arises from the fact that while the students are actually on school property, the school district is acting in loco parentis. And that duty ends when the child leaves the property. Unless, like I said, there's some sort of hazardous setting that is foreseeable. And there's not
Again,
one.
as I've indicated, we're going to have to look at all the factors, and I don't disagree with what you're saying, setting that up, but we have to look at all the factors to see if that exists.
Sure, and we've laid it all out in our briefs, to which I would refer the court. Briefly, we also make a proximate cause argument. I understand that proximate cause, a ruling in favor of a defendant as a matter of law, is rare in summary judgment, but we respectfully submit that this is one of those cases where it's appropriate and that it falls directly and squarely within this court's decision in Sullivan versus Welsh.
Thank you very much.
May it please the court, to address first the premises liability, I would refer this court respectfully to the cases of Zane versus Corbett, which relied on Dolores versus New York Central Railroad Company, 275 New York 55 1937. That case was one of my favorites, the shooting ducks from the train case. And what the defendants are trying to do here is displace the focus from what occurred on the school premises. The fact that the suicide did not occur on the school premises is of no moment. And I believe that the Boyle case, there was no notice of bullying. I believe in that instance that the school it wasn't over a long period of time, and there was not a bullying policy that was ignored and or avoided and not addressed at all. I'd also like to address in the reply brief of the defendants, they identified Zuckerman on the basis of the standard for summary judgment for the non-movement, and that's absolutely backwards. The case states that it is for the movement to establish that the cause of action or defense sufficiently warrants the court as a matter of law to grant judgment. So the question here is whether or not the defendants acted reasonably, whether or not they had a duty to control third parties, which they do, and I don't think the defendants dispute that, whether or not they were reasonably aware of the duty to control third parties, and whether that foreseeable harm was one that was foreseeable. That is a question of fact. Whether or not a jury could reasonably conclude that, we believe that that is the case in this situation. The defendants seem to be arguing that there should be some special exemption for schools. That is not the case under the law, and it is not speculation or unsupported that Gregory Spring was bullied. It is not speculation or unsupported that the defendants had noticed, both constructive and actual, that he was being bullied, and they had noticed, both constructive and actual, that bullying unabated can cause harm to children, specifically the notice of risk of suicide. So unless the court has any questions. Thank you.
718 Kim Stantz versus New York Central Mutual Fire Insurance Company. You just have to wait for Mr. Snyder to come up.
Understood, Your Honor. Thank you.
Perfect. Thank you. Go ahead.
It is still morning, so good morning, and may it please the court. I'm Thomas Lyons, and I'm here on behalf of the appellants Kim and Michael Stans in connection with this matter.
Basically, if I understand your argument correctly, Counselor, it's Gervant. What are the name of the cases in the Court of Appeals?
That is exactly it, Your Honor.
The language that I think your brief says is on point.
Directly.
You get a chance now to go to litigation de novo, whatever the language is of the case. And that's what we really have to focus on, is whether or not we agree that Gervant is controlling her. And I don't mean to steal your thunder, but that's how I read your brief.
Judge, you summed it up perfectly. It really comes down to that one limited point of law is, did the lower court err? And Gervant is directly on point. It addresses this precise issue. Beyond that, Judge, I would point out one other thing that is, to me, it's glaring from the briefing in this case, is there has been zero citation from the other side to any case that goes in the direction they advocate for, which is, yes, it can go to a second appraisal despite finding a first appraisal award should be set aside.
Even if they could find a case, that case would have to tell us about Gervant, because Gervant's the highest court in the state.
Correct, Your Honor. Meanwhile, we have cited Gervant and 17 other cases in a proverbial survey going directly how we explain, and Insurance Law 3404, which this was a fire loss, is the New York standard policy, and it speaks in terms of a appraisal.
And do you find any significance to what some might perceive as a change in position by the other side? That is, first they're saying this is fatally flawed in terms of the decision of the umpire and the arbitrator, the appraisers, I should say, and now they're defending and saying we should reinstate it. Sometimes inconsistent positions are revealing of the strength or lack thereof.
That is exactly correct, Your Honor. In the lower court motion practice, the only motion that was pending before the judge was our motion to confirm the appraisal award. And in connection with that motion, the carrier vehemently opposed and targeted what they viewed as rampant misconduct by the umpire in connection with this first appraisal. Now, only when we are saying, okay, we're not challenging that first appraisal award should have been set aside, but in that happening, we now are allowed to litigate de novo. Now, the carrier says, oh, but wait. The second appraisal that was ordered with this same...
That was sort of the point I was making, right?
Correct, Your Honor.
Okay, I think we understand.
Yes.
Thank you.
Pending any further questions, I have nothing. Thank you.
Mr. Snyder, can you good work.
Good morning, Your Honors. Brandon Snyder on behalf of the respondent, New York Central Mutual. As outlined in our papers, we believe the trial court's order should be affirmed in all respect on 3 bases. First, that the petitioners did not preserve this issue for appeal. Second, that the trial court correctly remanded appraisal. And third, that the ultimate resolution here gives plain meaning to the New York State legislative policy and appellate cases on point. As it relates to the first appraisal award, we note that the subject policy lays out certain requirements for an appraisal award to be binding. It has to set out the ACV.
Counselor, let me just interject here too, like I did for the other side, so I can play it even. We really have to look at whether or not Gervant controls here, correct?
Yes, Your Honor, in terms of whether or not to set aside the appraisal award, which was found in Gervant.
Not so much set aside, but what the next step is in the process. As I understand it, the appellant has pretty much limited their contention on appeal to what the next step is. Your position now is it's a further appraisal. Their position now is that it's litigation de novo. And that's what the issue is. I understand it, that's presented for this court to decide.
To an extent, Your Honor, respectfully, where I will push back a little bit on that point would just be that in the cases cited by the petitioners, the misconduct appeared to have poisoned the appraisal. We're talking fraud or bias. Here, there were mistakes made by the umpire that could be corrected, such as outlining the different valuations.
Mr. Snyder, as I recall, your client referred to the appraisal process as fatally flawed. And now on appeal, you're indicating that we should reinstate the appraisal award.
The second appraisal award, Your Honor, the first appraisal award NYCM maintains was fatally flawed. It did not follow the policy. It did not provide an ACV, RCV, or depreciation. It did not take into account the previous payments, which totaled $370,000, Your Honor, or the deductible Even the petitioner's own appraiser stated this was a highly unusual appraisal award because it didn't have those valuations. So this didn't poison the appraisal process, but it certainly needed to be modified to reflect what is required by the policy and what traditionally is involved in an appraisal award. And we believe in this, the trial court appropriately exercised its discretion and remanded it where this issue quickly could be fixed, Your Honor. And the second appraisal award did satisfy all these criteria. It did have an ACV, it did have an RCV award, it did have depreciation, and it was signed by 2 of the 3, NYCM's appraiser and the umpire, Your Honor.
Anything further?
Other than that, the one point I would make is that at the trial court, the petitioners asked to confirm an appraisal award. Nowhere in their submissions to the trial court before a decision was rendered did they ever ask the trial court to send it back to litigation. And in McGuire, a 4th Department case in 2023, this court held that novel issues should not be considered on appeal. NYCM respectfully offers that the petitioner's appeal procedure is improper for this reason. Other than that, if the court has no further questions, we rest on our papers, Your Honors.
Thank you very much.
Thank you.
719 Courthouse versus State of New York.
Thank you.
No. Go ahead, but you need to unmute yourself. I believe that opposing counsel has now submitted.
Oh, okay. Thank you, Your Honor. Laura Etlinger for Respondent, State of New York. Our position is that the Court of Claims correctly dismissed this claim on the basis of absolute immunity under claimant's allegations, including the changed allegations that he raised in opposition to the state's motion to have the claim dismissed. He was not confined without the limited due process protections that are required in prison disciplinary proceedings. The regulations involve the right to present documentary evidence, to request documentary evidence and have witnesses, and to employee assistance, and they've not been extended to the allegations underlying the either set of allegations underlying the claim here. And there has been no due process right to the type of Brady type right that claimant is asserting.
So you'd like us to affirm?
Yes, absolutely. Thank you very much. Unless the court has other questions, we'll rest on our brief.
Thank you. 720 Drake versus Village of Lima. 1 minute. Thank you.
Good morning, Your Honors. I just squeaked in there with a good morning. May it please the court. Shannon Vandermeer on behalf of the appellants, Village of Lima and Village of Lima Public Works. Before I get started, I just want to make one quick point, which is that we made a partial motion to dismiss. I believe that this case was classified as a summary judgment. Neither party disputes that this was a motion to dismiss, so the CPLR 3211 should apply here. This case is a simple case alleging negligent maintenance, and that is why the public nuisance claim should remain dismissed. That's why the takings claims should remain dismissed, and that is why the private nuisance and the trespass claim should have been dismissed as well. There's no intentional.
Would you mind if we jumped ahead to the claim regarding the elderly, I think grandmother or mother of Ms. Drake, perhaps?
Yes, Your Honor, no problem. That was going to be my second point, so I will jump to that.
Okay. Just with respect to that, it would seem that the notice of claim didn't make a specific reference. I don't think that it has to, though, in terms of the degree of her injuries. It also doesn't really change the theory. It's just an element of damage. So why should Why shouldn't that remain, that claim?
Your Honor, we're not arguing about the particularization. What we are saying is that by now claiming that dementia was worsened, that is a distinct claim. That is a claim involving a physical injury, and that type of claim is something that needs to be set forth in the notice of claim. We're not suggesting that just because they didn't say worsening dementia wasn't included, that that's why it should be precluded. What we're saying is that because there was no reference or suggestion that they were pursuing a physical injury claim in conjunction with the property damage, that is why that claim needs to have been dismissed.
But counsel, didn't they say they were pursuing emotional distress? Isn't that a physical claim?
They do say that, Your Honor, but that is not a physical injury. And the cases that were cited by both sides explains why the emotional distress was not sufficient. When you allege a claim for emotional distress, that's the garden variety emotional reaction to an incident, which does not necessarily require medical proof. Here, by claiming that the dementia was worsened, that's putting the medical condition directly at issue, which is then going to require medical proof, which is not something that is typically needed for an emotional distress. And that's why...
That's not always true, Counselor. I mean, I can tell you that on the Supreme Court, when I was there for many years, that this came up all the time. What came in with the ambit of emotional distress or loss of enjoyment of life? The defense obviously wanted to be prepared for trial and was trying to narrow that down. The plaintiff would say, well, this could be included, this could be included. This is fairly common for the trial courts to deal with down the road. You're saying that we should simply dismiss it right now because it's not particularized in the notice of claim. That's your argument, right?
That's our argument. And in addition, our argument is also that this is a physical injury. I respect what Your Honor is saying about emotional distress claims and what may be needed to prove, but by alleging worsening dementia, that's impacting the brain's functioning, which is a physical injury, and that is why...
You're saying that doesn't cause emotional distress. Of course, you're going to have to counter and say, yes, Judge, it does, naturally. So it could fit within the category, but it might be broader than the category.
We're saying that it goes into the category of a physical injury, and that because there was no reference to a physical injury, just simply alleging emotional distress or simply alleging loss of quality of life, that's not sufficient, particularly when you look at the incident as a whole. The incident as a whole is talking about the damage to the property of a house. That's not indicating that it's going to somehow then relate to a physical injury. And that's why there should have been some reference with regards to either the dementia or the physical injury. Obviously, our other points are in our brief. I know it's been a long day, so I will rest on our papers. Thank you, Your Honor.
Thank you.
Good morning, Your Honors. I am also squeaking under the noon, so I can say good morning. I think I was going to touch on 3 points and rest on my brief for the rest of it.
Doesn't the counselor make a good point here with respect to now you're alleging a physical injury as opposed to an emotional injury? How do you respond to that?
So our notice of claim included lost quality of life and garden variety emotional distress. The case law that we provided illustrates that those 2 claims includes physical impacts. So I think the brief kind of clearly lays that out. The one other thing, excuse me, sorry. The one other thing I will just mention is that, that factual allegation was really made on behalf of all plaintiffs. So it wasn't just about Miss Lillian Coates. It was really, frankly, going towards the experience that her daughter, Miss Eileen Drake, experienced. So she watched her mother go from being happy, functional, content in the bedroom on her first floor, fast forward to watching her mother stand in raw sewage, to fast forward to watching her mother be in a senior housing
So you
community.
would say the emotional distress or loss of enjoyment of life, whatever, could include the discombobulation that the occupants of the home experience in whatever form it may take.
Yes, yes, exactly. Mental anguish, inconvenience, discomfort, all that really falls under the lost quality of life, which is certainly, damages related to a tort, nuisance, negligence, and then the garden variety emotional distress, again, brings in the mental anguish and, a physical, experience related to this incident specifically. The second point I'll just make quickly is our trespass claim. The village, says that there's no intentional conduct alleged and that, that could have risen to a claim for trespass, but the lower court was really right to disagree here. We specifically alleged intentional conduct. The village argues that that the village needed to intend that there was going to be a clog in the sewer line, and then frankly, that's just not what the law says in New York. They have to, the intent goes to the act that is going to be the inevitable consequence of the unlawful intrusion. So the act of failing to maintain, operate, inspect, the inevitable consequences that there's going to be clogs in the sewer line, and where is that raw sewage going to go? It's going to go into the village's citizens' homes. My last point will be just on this inverse condemnation de facto taking claim. This is something we believe the lower court got wrong. They believed, or the lower court believed, that we didn't allege any permanent physical, taking of property, and we believe that the court really just read the term property too narrowly. We cited cases showing inverse condemnation de facto taking claims that were successful when only portions of a property were taken. So when the raw sewage came in from the sewer line up into the lateral, past the basement, up into the first floor, and began pouring out of the drains, the sinks, the bathtub, the toilet, all onto the first floor, and began raining down into the basement, flooring, subflooring, the furnace, the hot water heater, portions of the wall were all permanently destroyed, permanently taken, and we believe that gives us rise to inverse condemnation de facto taking claim, and would ask that you reverse.
Thank you very much. 721, Deborah Calhoun versus Sharonda McClain. Did I get that right? Okay. People keep saying close enough, which means I haven't gotten anything right all day. Okay.
I'll be the first to say good afternoon, Your Honors. The question before the court is whether a plaintiff is entitled to basic discovery prior to the filing of a summary judgment motion, which is based exclusively on affidavits and otherwise inadmissible or documents that are not in admissible form. In this instance, we have gaps in our record, which is largely undeveloped at this point. It's always been plaintiff's position that a summary judgment finding at this point is premature, that at a minimum, the plaintiff should be entitled to discover what evidence does exist, up to and including evidence that has been somewhat revealed by the defense in their motion. We understand that there are a number of cameras located at the house. We've been given a very brief 36-second snippet from one of them, but there are 3 different stills that were provided with the motion. We've never seen what happens before or after this incident. And in fact, based on the information that's provided, we're taking it on faith that the truck was in a driveway as opposed to just parked on the grass, for example, which we haven't even had a chance to explore the fullest reaches of VTL 388, but it may bring this case within the implied permission granted to a defendant, or to a plaintiff under VTL 388. I think that section is in and of itself important to this case because it speaks to the protections that are afforded to innocents on the roads in the state of New York, that we have to tread very carefully when we're talking about vehicles, and specifically owners and their insurers who are claiming that a vehicle was taken without permission, and so therefore neither the owner nor the carrier should be held liable for the damages that arise from this
That's not really
operation.
what they're saying here. They're saying it was stolen. They're not saying that somebody took it without permission, that's a whole different thing.
Your Honor, we're not saying it's stolen, we're saying we don't know. We're saying if it was stolen, there's a potential that VTL 388 applies. But we don't know enough about the basic facts in the case to determine one way or the other. What we do know is that there are inconsistencies in the record that was provided by the respondent that includes the Geico report, which was submitted as Exhibit C to Mr. Kendall's affidavit, where I don't know what just this hanging clause, "I was missing," means. And we haven't had the opportunity to explore that question with him. We also haven't had an opportunity to explore the question of if you started the car, Ms. Du Bois, at 6:20, and that you left the car for less than a minute and found that the car was stolen, as you claim, during that time, why was the report not made until 6:56? Any number of things could have occurred during that time, including a car having been given over to a friend. There could have been a falling out in this relationship and an argument that ensued that explains the 36-minute gap. I don't know. And the fact is we should at a minimum be allowed to bring these people in within the context of this litigation where they are compelled to provide answers under oath. We should be entitled to ask these questions. It may work out at the end that we're in the exact same position, but I believe
we
that.
have your argument.
Thank you.
Good morning, Your Honors. Martha Donovan on behalf of Respondent. In response to Appellant's argument regarding the admissibility of the evidence, I don't believe that was ever discussed in the briefs and is therefore not preserved on appeal. And then with respect to the videos, there's no requirement that all the evidence be produced in support of the summary judgment motion, simply that a prima facie case is made. And the prima facie case here was established through the affidavits, through the video evidence and the still shots from the cameras, through the Buffalo Police Department accident report and the Geico theft report.
Well, counsel is saying you hold some of the evidence that they might need to rely on, and so they have a right to ask you for that in discovery.
But in order to show that it's premature, they have to show how that evidence would lead to a different result, and they haven't done that. It's a simple, what he said is speculation. It's a fishing expedition.
Well, just in terms of the time gap, if we were to assume, for the sake of argument, that that it wasn't a minute, that she didn't run into the house for a minute, she ran into the house and then something came up, somebody called her or something else, and actually the car was sitting there running for a half an hour. And that when she came back out and the car was gone, that's when they called the police. And then they went back and looked at the tape. If that's actually the case, they haven't seen all that because it hasn't been discovered yet. Could there be any liability under that situation?
No, these are sworn affidavits under oath. There's really nothing here that smells. They reported this to the police. They filed the report with Geico. They said that they would, if these gentlemen were apprehended, that they would prosecute. I mean, there's nothing here that's inconsistent. And the case law is that if there's nothing that goes against the evidence, then there's no reason. Maybe
I'm making the wrong assumption. The 6:20 a.m. I went into my car at 6:20 a.m. I assume that came from the surveillance tape. That's when they saw that the two unidentified males stole the car. That was at 6:20 a.m. So that's obviously where the claim's coming from. Is that right or no?
Yes, in her affidavit, she said that she was getting ready to go to work. She went out, started the car, came back in, and then the car was stolen while she was in the house.
Right, but she's claimed, I mean, her claim is that she came outside at 6:21 a.m. or so, and then went back into the house and called the police at 6:56 a.m. Right?
I believe so. I don't have all the numbers committed to memory, but I believe that we met our burden on summary judgment to demonstrate that we rebutted the presumption of permission and consent.
I understand. Thank you.
Thank you.
Thank you.
Thank you. 725 through 726, Donald Holler versus O'Connell Electric Company.
Good afternoon, Your Honors. Seth Weinberg for the defendant appellant here. And I think where the Supreme Court got it wrong in this case...
Remind me which client you have.
I have O'Connell, which was the...
O'Connell. Forgive me, I got the defendants confused. Of course you're O'Connell.
Thank you, Your Honor.
I'm showing the time of day, apparently.
Well understood. The obligation to procure insurance is not the same as the obligation to be an insurance company.
Well, this is where I'm confused. So let's start with that point. As you point out in your brief, all the cases that Supreme Court relied upon and that the other side relies upon are against insurance companies.
Correct.
The context of those cases, as I read them, was in a DJ action, typically, right?
I believe almost uniformly.
What's that?
I believe uniformly, not just
Yeah,
typically.
right.
Correct.
So the way this would typically work, assuming that the contractor, your client, actually did buy insurance, I think it was through Liberty for the primary and then Travelers effectively for the over.
I believe that's correct. I forget the tower exactly, Your Honor, but
Right.
okay.
So in any event, the way this would typically work is one of two ways, as I understand it. That is, when the contractor fails to get the insurance as agreed, then the contractor, your client, could be on the hook, potentially. But when you actually go out and get insurance, then it has to be tendered to your insurer by the additional insureds. And if the insurer, as in those three cases, beginning with the Court of Appeals cases, doesn't pay up or doesn't agree to defend, then the DJ action is brought against the insurer, right?
In essence, yes. So it's two separate claims. The only claim that could have been brought against my client is a failure to procure insurance claim.
But the court dismissed that because...
And it's not been appealed.
Okay, so
Correct.
we're beyond that.
We're beyond that.
So theoretically, on today's, if I have this right, the state of the record theoretically could be the other side could go propose a judgment, theoretically, to say, we get this money directly from O'Connell by virtue of a judgment, rather than going to get it from Liberty. So it comes out of your client's pocket directly, rather than Liberty. Is that what's going on here?
That's my understanding of what the order actually says, that we are to provide primary non-contributory insurance. But we're not an insurance company. Insurance is not only a large industry, it's a well-regulated
They have
industry.
insurance. They can go get it.
If there's a dispute about what our policy covers and doesn't cover, that's for the separate DJ.
Right.
And that'll hash out however it hashes out. So not only, and with Your Honor's permission, I transition to the contractual indemnity piece because this is relevant to that. I think this is a good transition point. In those DJ cases and in all those insurance cases, they all say an insurance contract is like any other contract. There is, however, one large distinction. An insurance carrier's obligation to defend is broader than its duty to indemnify. And therefore, there doesn't have to be proof of what the plaintiff, the underlying plaintiff, is alleging. It just has to be alleged to trigger the defense. What the appellate divisions across this state have said, in a private indemnity contract, I'll call it, a non-insurance indemnity contract, the duty to defend is no broader than the duty to indemnify. Therefore, it's not enough for the plaintiff to allege my client was negligent. It has to be proven my client was negligent, and only then is my obligation to defend triggered. The Supreme Court in this case ordered me to immediately defend, specifically because there were allegations.
The way I look at this appeal, and please correct me if I'm wrong, especially given the lateness of the day apparently, that this whole appeal is about defense costs before it's figured out who's actually liable. The bulk here, if I'm your client, I'm like, whoa, you're taking the money out of my pocket and not out of my insurance? So do I have it right that most of this appeal is about defense costs?
I'd say half, because it also requires us to indemnify already.
But that's a conditional order of indemnification, right?
We don't know what the condition is. It just says conditional. And
I thought the way the court wrote its decision, the way I read it anyways, was that ultimately this is going to get sorted out at trial. If it's the general contractor that's primarily responsible for maintaining the premises that ended up causing ice or slip and fall kind of thing, right, then you're not on the hook at all for indemnification.
which would be odd if I'm on the hook for defense when I have no duty to defend, if I have no duty to indemnify. It can't work. So the immediate concern, Your Honor, is certainly defense costs. And I think part of what one of my colleagues will come up here and say is talk about a clause in the subcontract that says we owe defense costs and get reimbursement after if they're proven negligent. My way to address that is essentially, just like a party can't contract to be indemnified for its own negligence because the general obligations law precludes it, a party can't contract to a defense regime that is contrary to established case law. You can write in a contract, I, subcontractor, will indemnify you, general contractor, for your own negligence. And the Court of Appeals has said is, on its face that may not be void, but if at the end of the case it turns out the general contractor is void, I'm sorry, the general contractor is negligent, it is void. So yes, you can put in a piece of paper anything you'd like. The question is it's enforceable, and we would submit it's not enforceable. And in this case, there is not only questions as to whether we're negligent, there's questions as to whether the other two parties are negligent.
And just to shoot this out of the air, so to speak, the cases like Bink and other cases about where it allows identification to the fullest extent provided by law, where you might be able to be indemnified for your own negligence. That's not involved in this appeal, at least not yet.
Well,
in this case.
those cases don't say you can't be indemnified for your own negligence.
Right.
You can be indemnified for the negligence of someone else that you're compelled to pay.
Got it.
So that that could be this case. We don't know because no one knows who was negligent, how much they were negligent
But
for.
that's not an issue on this appeal. I'm just trying to take that out.
No, it's not, because this record is not developed.
It's not even on this bill.
Right. So that's the most direct answer to that question.
Anything further?
I could discuss all the reasons why we think there's evidence the other parties were negligent here, but I think the court's well familiar with the record, so unless there are questions on that, I'm happy to rest on my brief.
Thank you.
Thank you all.
I have a question before you sit down. I'm so sorry.
That's fine, Your Honor.
Okay.
It's the combo privilege. You can
Yeah,
call me back.
yeah, so, I like that too. So Liberty, you're insured. You bought the insurance, you named, these other entities as additional insured. Well, where is Liberty?
Well, let me start by answering the simple question, which I don't know because it's not in the record. And here's why, to get back to Judge Curran's point, that has to be in a DJ. And to make this order even more strange,
So
it's providing insurance.
Is your answer that they wouldn't come in and get involved in this case without a DJ?
My answer is genuinely, I don't know, Your Honor.
How do you not know?
It's not in the record. I'm appellate counsel. I haven't had those conversations. What I would say is this, and I thank you for the question because it reminds me of a point I forgot, and I don't get to say I have to come back up, so I appreciate that. This order interprets insurance obligations without ever looking at the insurance policies. You can't do that. For an insurance procurement case, or more importantly, an additional insured issue, you have to look at the contract that required the insurance and the policy of insurance to see if the policy does or does not provide coverage. There could be an exclusion, there could be a million reasons. So without an insurance policy, how can we possibly say someone has to provide a non-insurer's primary non-contributory coverage?
There is the subcontract and the provisions there and the provision to get insurance, et cetera. I'm not sure that last point is a barrier, but certainly I'm very curious as to where is Liberty.
If I had the answer, I would certainly give you. I'm not trying to be obstructive, but what my point was simply, it is possible my client fulfilled its obligation to buy a policy. Let's take it out of the context of my client.
You allege that you did.
Right. We not only bought a policy, but bought the policy the contract requires. There are a lot of contracts that say buy form CG 210. I'm sorry, Your Honor.
No, you did all that and you named them as, additionals.
But then if we had in this record, let's say, a policy that has an exclusion in it, the insurer wouldn't have to cover. That doesn't necessarily mean my client breached its obligation to procure insurance.
But they usually like to tell us those things.
Understood, we just don't know.
Okay.
So-
In the context of a DJ action. And incidentally, it looks like the court granted DJ relief, but never actually entered a declaratory judgment.
Well, they can't because the insurance carriers aren't parties.
Okay, and again, you don't know why Liberty's not here, so I think.
I'm just trying to answer the questions, Your Honor. I appreciate your point.
Thank you.
Thank you.
Who do you want to go? It's up to you.
Who's the owner?
I can go.
I'm the owner, but I'm not the third-party plaintiff that brought in.
Okay, thanks.
And I apologize, I checked off the wrong box when I logged in, so it's showing me in the gallery, not as a participant.
Okay, go ahead.
I'll start by answering Judge Bannister's question. Where is
O'Connell's insurance company, and.
Is it in the record first of all?
It's not in the record, but it was a question posed, so I thought I would
Okay,
address it
but
first.
That asks us to go beyond the record.
Yeah, so
I'll
yeah.
defer to Justice Bannister on that, but.
Okay,
Sure.
and I won't make you answer that question, but let me ask you this, I mean, was there notice to them, that may be in the record, that they were notified that this is a claim, like, you know, I was on Supreme Court for a long time, and no insurance company would like another defendant to hire their own counsel, run up their own separate bill without their, you know, oversight, like, this just seems so, you know, antithetical to, you know, things that have happened as a regular course for a very long time.
That's correct, and it's also unnecessary. LMC did tender to the insurance company, and it was rejected. And
That's not in the record.
It's not in the record.
Okay, let's stick to
But-
the record.
Sure, so LMC.
But your cause of action for breach of the promise to get insurance and name your client as an additional insured has been dismissed because in fact, the other side did what it's supposed to do, and that is in the record, where the court said, yes, you are named as an additional insured. What happens between your client and and it is in the record, the name of the carrier, which is, I believe, the primary is Liberty. Whatever happens between your client and Liberty, you're an insured, an additional insured to them, correct? Whatever happens to that is outside this record.
Sure, the claim for breach of the insurance procurement provision has been dismissed.
But it doesn't change the fact that O'Connell is not an insurer in this situation, correct?
They're not an insurance company, but LMC did not tender the defense and indemnity under the insurance policy. They chose to do it under the subcontract, directly to the subcontractor who agreed to protect it against claims such as this.
So, but that means you're under the private contract, so as your opposition said, the law, as I understand it to be, is that the duty to defend is coextensive with the duty to indemnify, and inasmuch as you have not been awarded outright indemnification yet, you don't have defense costs awarded from O'Connell.
That is O'Connell's argument, but there are two cases, the Intercity Development Corporation case and the Strands case, both address this, and they both made the subcontractor pay directly when it was tendered under the subcontract. So there is case law that is contrary to O'Connell's position, that is supportive of LMC's entitlement to defense costs and indemnification.
We'll look at that, right?
Sure. And I know there's a lot of time spent on the declaratory judgment action, and it just doesn't make sense to force a party that is so clearly entitled to a defense and indemnification from a subcontractor and their insurer to have to file another action and under another docket that will require discovery, summary judgment, and most likely an appeal just to get what is very clearly unstated underneath the subcontract. And then after LMC does all of that, O'Connell's going to argue you can't get chase fees. They're going to run up the bill unnecessarily, and then my client's left with holding the bag on all the expenses. So unless there's any other questions, I'll
Just
wrestle.
Strands is a self-insurance case, correct?
It was, and so
that's what makes the client the insurer, because they're self-insured. That's the distinction. So when you cite the Strands, O'Connell is not self-insured, correct?
They do have a high deductible plan that they do have to pay, so in essence,
Was
they
that
are
an answer to
self-insured.
my- In essence, okay.
But in just one more point, I'm sorry, Judge Smith. In that Strands case, the court said it doesn't even matter that you have to pay out of your own pocket because you agreed to indemnify them. So they tried to get out of that obligation by saying we're self-insured, we're not an insurance company, but the court didn't let that happen. Thank you, Judge.
Thank you.
Good afternoon. I just want to address the Strands case. The case actually held that the amount of the retention by the third-party plaintiff, who was the one seeking coverage, was the one that was entitled to the insurance from the third-party defendant, who was well, in our case, who is the subcontractor. Other than that, I just like to point out, my client is basically a recipient of or entitled under the prime contract, where any subcontractors owe the same duty to my client. Other than that, I'll rest on my brief. It's late in the day.
Thank you. Any questions? Thank you. Is he ready? I don't know.